President.
The senator from Wyoming.
Thank you, Mr. President. I appreciate this opportunity today to move this legislation that is bipartisan, and it protects our environment, and it helps small businesses all across the country. S. 1140, the Federal Water Quality Protection Act, is legislation that I introduced along with a number of Democrat senators, Senator Donnelly, Heitkamp, and Manchin, along with many other senators. The senator from California previously spoke, and I would just point out to her that the California Chamber of Commerce supports my legislation. The California Farm Bureau supports my legislation, because this legislation will protect our nation's navigable waters and the streams and wetlands that help our navigable waters stay clean. This bill is a testament to the hard work both sides of the aisle have done in achieving an agreement on an environmental protection bill. Our rivers, our lakes, our wetlands, all other waterways are among America's most treasured resources. In my home state of Wyoming, we have some of the most beautiful rivers in the world: the Snake River, the Wind River, dozens of others. People from around the world come to Wyoming. They come to visit because we have an environmental landscape that is second to none. Anyone who has come to my state and experienced Yellowstone National Park, the Grand Tetons, the Bighorn Mountains, comes away with a sense that Wyoming is a pristine and beautiful place. It's what Wyoming sells, and it's what makes Wyoming so unique. So the people of Wyoming are devoted to keeping our waterways safe. We want to preserve the water for our children and grandchildren. We understand that there is a right way and a wrong way to do it. It is possible to have reasonable regulations to help preserve our waterways while respecting the difference between state waters and federal waters. This is the environmental legacy that my constituents want, and it's a legacy that they have earned for their decades of sound management. It is the people of Wyoming who have kept Wyoming's waterways pristine and beautiful. So the EPA has now released new rules. The new rule is called the Waters of the United States Rule, WOTUS. This rule doesn't work for the people of Wyoming. It most likely doesn't work for any of your constituents either, certainly not for those who have to put a shovel in the ground to make a living. The courts have begun to weigh in with their concerns about this WOTUS rule, and they've actually given Congress and stakeholders a necessary pause. That's why we're here today. Judge Erickson of the District of North Dakota in August of this year issued an injunction that blocked the Waters of the United States rule in 13 states. He did it because the rulemaking record was, in the judge's words, inexplicable, arbitrary, and devoid of a reasoned process. He also stated, with regard to the rationale behind the EPA's threshold for what is and is not federal water, again, in the judge's words, on the record before the court, it appears that the standard is the right standard only because the agencies say it is. The United States Sixth Circuit Court of Appeals then put a nationwide stay on the rule on October 9th of this same year. In granting the stay, this is what the court said: the sheer breadth of the ripple effects caused by the rule's definitional changes counsel strongly in favor of maintaining the status quo for the time being. Let's keep it as it is for the time being. The court added, they say, a stay temporarily silences the whirlwind of confusion that springs from uncertainty about the requirements of the new rule and whether they will survive legal testing. So what the courts have done basically is said, let Congress have time to act. Now, we don't have to sit on the sidelines and watch this rule slowly crumble under legal scrutiny. Contrary to some activist groups' rhetoric, we are not facing an immediate environmental water pollution crisis. In fact, the Sixth Court stated that in granting the stay that neither is there any indication that the integrity of the nation's water will suffer imminent injury if the new scheme is not immediately implemented and enforced. They even called it a scheme. We now have the opportunity to do better. And to do better, we must act now. That's why we must take this opportunity to pass the legislation before us that will have EPA do a new rule under a specific set of principles outlined by Congress. These are principles that protect navigable water and adjacent wetlands, as well as farmers, as well as ranchers, as well as other landowners. Now, I know that some senators gave the administration the benefit of the doubt with this rule, despite concerns they've heard from their constituents. And those senators waited for the final result before making a judgment to see if those concerns would be addressed. I'm here to tell you today, Mr. President, that whatever concessions the EPA says they made to address some of these serious problems raised by their proposed rule, the EPA added new provisions in the final rule that greatly expand their authority. This is disappointing, because I believe the great majority of senators voiced concerns in the process, and those concerns fell on deaf ears. The EPA has produced a final rule worse than the one that they originally proposed. Here's an example. Instead of clarifying the difference between a stream and an erosion on the land, the rule defines tributaries to include any place where EPA thinks it sees an ordinary high water mark. What looks like, not what is, what looks like what they think is this ordinary high water mark. Even worse, EPA proposes to make those decisions from sitting at their desks, using aerial photographs, laser-generated images, claiming that a visit to the location is not necessary. Under the rule, the Environmental Protection Agency also has the power to regulate something as, quote, waters of the United States if it falls within a 100-year floodplain, or if it's within 4,000 feet of a navigable water or a tributary. And the EPA claims there's a significant nexus. So what's a significant nexus? Well, under this rule, a significant nexus can mean a water feature that provides life cycle-dependent aquatic habitat for a species. So if you're drawing 4,000-foot circles around anything the EPA defines or identifies as a tributary. Now remember, 4,000 feet. I mean, we're talking over 13 football fields long, and everywhere there is a potential aquatic habitat. Look, essentially almost the entire United States, according to this, would be underwater. Actually, 100% of the state of Virginia is under this jurisdiction. 99.7% of the state of Missouri falls within this area, underwater, if you will, according to the EPA guidelines. Now, I'd like to take a moment to talk about puddles, because one of the previous speakers on the other side of the aisle talked about puddles. Now, people know what they think about when they think about a puddle, you know, like when it rains. Well, the final rule does exempt puddles, defined as very small, shallow, and highly transitory pools of water that forms on the pavement or uplands during or immediately after a rainstorm or similar precipitation event. I guess that would mean like when the snow melts. The rule specifically does take control over other pools of water created by rain, like those that we have all around Wyoming. Prairie potholes, vernal pools, even if the land where the pools of water form is far away from any navigable water or even a tributary. Under this new regulation, Mr. President, nearly all of these pools of water created by rain will now be considered waters of the United States, giving the Environmental Protection Agency the power to regulate what you do on that land. These provisions are sweeping and will create unnecessary and uncertainty activities in communities all across the country. Mr. President, there's plenty that I've already outlined in the Waters of the United States rule that's bad for agriculture, with the many methods it provides for federalizing previously state-controlled water. I mean, the states had made these decisions in the past. Now we're adding another level of government bureaucracy. This rule is bad for agriculture, for those people who produce our food. Farmers, ranchers, and others are used to working with their states to protect their land and water under their own stewardship. But I will tell you, Mr. President, we heard from the senator from California about groups opposing this. 480 different groups support this bill, and they are major national groups: the American Farm Bureau, American Retailers Association, American Soybean Association, American Sugar Alliance, the Milk Producers Council, the National Association of Wheat Growers, the National Cattlemen's Beef Association, National Chicken Council, National Corn Growers Association, National Council of Farmer Cooperatives, National Pork Producers Council, National Turkey Federation, U.S. Poultry and Egg Association, United Egg Producers, USA Rice Federation. I could go on and on. These are the food producers of America. They support the legislation in front of the Senate today. Point is that not one state, not a single state in this country is out there that doesn't have a strong agriculture presence. We all do. So I urge all senators to make sure, as you prepare to vote on this motion to proceed, that you check with your folks at home. I'd also note that many industries outside of agriculture are concerned with the rule as well. These include manufacturers, home builders, small businesses, you name it. They're all very concerned with this rule, and they want Congress to act now. Action could mean Congress can pass a Congressional Review Act resolution, which will be considered possibly later in the process. But that would eliminate the WOTUS rule and prevent a substantially similar rule from being proposed. That would allow for a new rule, as long as it was not substantially similar to the existing one. We need to vote on this resolution because I believe that S 1140 is a better route, the one that we have here today. This is the bipartisan compromise. This is the bill that has a number of senators from the Democrat side of the aisle co-sponsoring the legislation. As most importantly, this piece of legislation on the floor today allows for Congress to establish the principles. Congress to establish the principles of what the new EPA would look like. Now, I know there are a number of Democrats who have ideas to improve the legislation that's on the floor today, specific for their own states. If my colleagues vote to proceed, the motion to proceed at 2:30 this afternoon, we will have an open amendment process that would allow members to improve S 1140 in a bipartisan way. We're willing to work with anyone who wants to improve this rule in a bipartisan way. But let's not sit on the sidelines anymore. Rather than support an EPA final rule that actually makes it worse and was worse than the proposed rule, a rule that will likely not survive legal scrutiny based on what we saw from the courts, a rule that doesn't represent the interests of our farmers, ranchers, families, small businesses, our communities, let's move forward with the bipartisan Federal Water Quality Protection Act to assure the public that we hear and we understand their concerns. At the same time, let's give EPA and the Army Corps the certainty that they need to confidently move forward with a new rule, a rule that truly reflects the needs of the constituents that we represent. Let's protect our nation's waterways for the long term. Thank you, Mr. President. I yield the floor.